Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Adi Hafiz bin Adam. My metric number 1232063. I'm from the Ali 02 Administration of Islamic Law in Malaysia. Today, I will present about the case of Pendakwa Syarie Pahang vs. Kartika, Seri, Dewi, Binti, Shukarno, 2010, 30, Counts 2, JH 269. Alright, now I will explain about the table of contents. First thing first, I will explain about the case overview, next objective, third facts of the case, next course decision, applicable law, issues, discussion, justification, recommendation, and last but not least, the conclusion. Alright, now I will explain about the case overview. The accused name is Kartika Sri Dewi Shukarno. The hearing date is on 1st December 2008, and the court is at Syarie High Court in Pahang. And who the president judge? The president judge is Chief Syarie Judge Datuk Seri Abdul Rahman Yunus, and no case referred for this case, and this case will become a landmark case. Alright, what the objective of this case? First, to analyze how Sharia law is applied in modern Malaysia, particularly concerning moral offences. Next, to explore the rationale behind the court's decision and its alignment with Islamic jurisprudence. And lastly, to discuss the broader implication of this case for the Malaysian legal system and society. Without wasting time, I will explain about the facts of the case. Alright, on the 11th July 2008 at 11:40 p.m., the accused was charged with drinking tiger beer at Sheraton Bay Lounge Hotel Legend, Sheraton, Pahang, Malaysia. On 1st December 2008, Kartika was formally charged under Section 136 of the Pahang Sharia Criminal Enactment 1987 for consuming alcohol in public. So she pleaded guilty to the charge acknowledging her violation of Islamic law. Sharia High Court in Pahang sentenced Kartika to 6 strokes of the cane and a fine of 500,000. This sentence was one of the first high-profile cases involving caning of a human for an alcohol-related offence under Sharia law in Malaysia. Okay, next. The sentence received widespread media coverage, both in Malaysia and internationally. There was a significant public reaction with opinions divided, some of support of the enforcement of Sharia law, while others, including human rights organizations, criticized the punishment as harsh and inhumane. The execution of the caning sentence was postponed due to the public outcry and intervention by higher authorities. The Malaysian Prime Minister at the time, Najib Razak, called for the sentence to be reviewed, considering the public sentiment and the potential impact on Malaysia's image. Next, on December 2009, the Sultan of Pahang, who holds the highest authority over Islamic matter in the state, eventually commuted Kartika's caning sentence. Instead of the caning, Kartika was ordered to perform community service for 3 weeks at a children's home. Next, Kartika completed her community service as per revised the sentence. And lastly, the case was closed following Kartika's completion of the community service, and it remained a significant point of reference in discussion about the application of Sharia law in Malaysia. Now, we are moving on to court's decision. So, the court's decision are the fines and cane that are imposed on Kartika for drinking beer treats the case not as a hudud, but the ta'zir offence, and a matter therefore of discretionary sentencing. The Sharia Court Criminal Jurisdiction Act 1965, as amended in 1988, limits jurisdiction of Sharia court stated that imprisonment up to 3 years or fine up to 500,000 ringgit or whipping up to 6 strokes. According to this case, Kartika Sri Dewi was charged under the provision of Section 136 of the Pahang Administration of Islamic Law and Malay Custom Enactment 1982, Amendment 1987. It provides any Muslim in any shop or public place selling, purchasing, or consuming alcohol is guilty of an offence, and upon conviction may be sentenced to a fine not exceeding 500,000 ringgit or to imprisonment not more than 3 years. Kartika pleaded guilty. However, the caning sentence imposed by the Kuantan Sharia High Court on her has been commuted to community service for 3 weeks on the orders of the Sultan of Pahang. So, what are the relevant laws that apply in this case? First, Section 136 Enakmen Pentadbiran Agama Islam dan Adat Melayu Pahang 1982 Pindaan 1987, it states that any Muslim in any shop on public place selling, purchasing, or consuming alcohol is guilty of an offence and upon conviction may be sentenced to a fine not exceeding 5,000 ringgit or to imprisonment not more than 3 years. Next, enactment Keterangan Mahkamah Tinggi Syariah Pahang 2005 is about an iqrar. First, iqrar is a confession made a person, either is in writing, orally, or by gesture, stating that he has an obligation or liability towards an other person regarding on certain right. Next, any iqrar confession must be made in court in front of a judge or outside court in front of two male witnesses who are of sound mind, have reached puberty, and are just. And clause 3, an iqrar relating to any fact in question or relevant facts is considered evidence. Is there any issue that arises in this case? So the answer is yes. Alright, first, human rights concerns. The sentence of caning for consuming alcohol sparked significant debate about the humaneness and ethicality of corporal punishment. International human rights organizations such as Amnesty International and Human Rights Watch condemn the punishment as cruel and degrading. Next, judicial discretion. The role of judicial discretion in interpreting Sharia law came under scrutiny. Critics argue that the court could have imposed a less severe punishment, taking into account Kartika's guilty plea and the nature of the offence. Next, uniformity of legal standards. The lack of uniformity in Sharia's law enforcement raised a question about the need for a standardized approach to Islamic jurisprudence across Malaysia to ensure equal treatment of all Muslims under the law. So the next issue is public reaction. Within Malaysia, the reaction to the case was deeply polarized. Some segments of the Muslim population support the court decision, viewing it as a necessary measure to uphold Islamic values and deter similar offences. Conversely, many Malaysians, including some Muslim groups, expressed outrage and called for a review of the laws that permit such punishment. And the last issue I will give to you guys is gender-specific punishments. The case drew attention to the gender-specific aspect of Sharia law enforcement. Kartika's case was notable because it involved a human being sentenced to caning, which is relatively rare and highly controversial. Alright, from this case, I will discuss about the three main points. Intervention by the Sultan of Pahang, judicial approach, and public perception. Alright, first, intervention by the Sultan of Pahang, who committed the caning sentence to community service, highlighted the role of higher authorities in the Islamic legal system. This intervention demonstrates the capacity for compassion and reconsideration within the framework of Sharia law. Next, judicial approach. The court's strict interpretation of its Sharia law reflects a conservative approach to moral offences, and the public reaction was divided, with some supporting and enforcement of Islamic principles and offences criticizing the harshness of the punishment. Now, I will give to you guys about the sum of justification. First, Sharia law enforcement. The justification for the court's decision lies in the strict adherence to Sharia law, which aim to maintain moral standards among Muslims. Next, deterrence. The harsh punishment serves as a deterrent to others who might consider violating Islamic principles. Now, we are moving on to the recommendation. I will recommend about the 3 points. First, consider revising Sharia laws to ensure they align with the contemporary human rights standards while respecting Islamic principles. Next, increase awareness and education about the implication of Sharia law to prevent similar offences. And last but not least, ensure uniform application of Sharia laws across all states in Malaysia to avoid discrepancies and confusion. Now we are moving to end, and I will give you guys about some of conclusion. From the case of Pendakwa Syarie Pahang vs. Kartika Seri Dewi Shukarno serves as a significant example of the application of Sharia law in Malaysia. It underscores the challenges of balancing religious law in with modern human rights concerns. While the Constitution was rooted in the desire to uphold Islamic principles, It also sparked a broader discussion about the appropriateness and consistency of such punishment in a contemporary society. So that's all from me, and I hope you guys enjoy and learn something from this case. Thank you very much, and Assalamualaikum warahmatullahi wabarakatuh.